What's your name?
Pollard.
All right.
Calling case number 240553801, the people of the state of Michigan versus Kevin Pollard. The defendant is charged with count 1, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older. This is the day and time set for bond redetermination. Appearances, please.
Judge, good morning. Stevenson for the people, T71917.
Your Honor, bring it on behalf of Mr. Pollard. Can I get a quick breakout room, 10 seconds, Judge?
Absolutely, absolutely.
10 seconds.
Okay. What is the bond for your client? Is it $250?
Cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does. But the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high part, some type of 10% bond. I think $250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And, Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSC first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the 250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everybody.
Mr. Ray, final words, if any.
I like that. No.
I wasn't privy to watching the arraignment, Judge, but obviously this court is very knowledgeable, and I'm going to, obviously leave it to this court. I wasn't privy to watching the arraignment, though, Judge, so I can't really speak on that.
See, where we I haven't heard their arguments of counsel. Where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess, an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed. And then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds. And whether there's sex there or not sex there, we have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers. And so, we're real concerned about this. So the $250,000 bond is an unaffordable bond. And so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts a bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. And Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate this bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash. Okay. It's $1 million now. It's $1 million now. Okay,
because he's on Social Security disability now.
I understand, but the court finds that Mr. Pollard, it may be some serial action that's going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24. I mean,
Yeah, it's when, it looks like it wasn't until October 14th of 2023 when the mother called asking who is this Kevin guy. So we just kind of got that information, And I'm not sure when the 12-year-old, I'm not sure when all the 12-year-old and the alcohol, when that happened. So it's a lot, Mr. Reagan. And so the timeline may get a little bit jumbled, but it's a lot of kids, teenagers, alcohol, sex, molestation. It's kind of blending. And so, we're here where we are.
Yes, sir.
All right, thank you. Ms. Pollard, you can leave.
Thank you, Judge.
All right.
Calling case number 24-055-30601. The people of the state of Michigan versus Krishan Shakur Nelson. The defendant is charged with count 1, operating license suspended, revoked, denied, causing death. Count 2, operating license suspended, revoked, denied, causing serious injury. Count 3, moving violation, causing death. Count 4, moving violation, causing serious impairment of a body function. Felony commission with motor vehicle adult advisory. Habitual offender, second offense notice. Today is the day and time set for bar redetermination. Appearances, please.
Judge, always a privilege. Steve Vincent for them.
Good morning, Your Honor. Jonathan Simon, P35596 on behalf of Mr. Nelson.
And where's Mr. Nelson?
The jail called and said that without Mr. Nelson being very combative, he wouldn't come out the room, so they're not going to try to get him out of the cell.
Okay. Do you waive your client's appearance, or would you like to adjourn this matter?
No, Your Honor, I'll waive his appearance. Your Honor, I appeared at the arraignment on the warrant. At that time, bond was set at $50,000 personal house arrest GPS tether. At the probable cause conference, there was a modification to allow Mr. Nelson to go to and from work. He works from 9 to 5. So the time was adjusted to allow him to be out of the house from 8 a.m. to 6 p.m. And there had been no violations. As a matter of fact, there was also a condition that he be allowed to attend another function, which he did without incident. Your Honor, the preliminary exam was scheduled for this past Thursday, the 25th at 10 o'clock. Before the exam, Mr. Nelson not being present, I texted, received no response. I called, it went to voicemail. Judge King called, it also went to voicemail. After about 15 minutes, capias was issued and bond was reset at $50,000 cash or surety, house arrest. Leaving the court, I was able to contact an associate of Mr. Nelson who was able to locate Mr. Nelson. He was at home asleep. Apparently, he's been so stressed out about this incident that he had not had any sleep in days. And then when he fell asleep, he simply slept through the exam. We did zoom in to the examination courtroom and spoke with Judge King and then notified the judge that we would be appearing the following morning at 8:30. I did appear at 8:30 that morning, but Friday morning, the 26th, but I learned that Mr. Nelson had already been picked up on the tether. He was at home about 3 o'clock Thursday afternoon and was taken into custody without incident. He was tethered. He was home. He simply just failed to appear and was denied the opportunity by that arrest to come in and turn himself in the following morning. Judge, quite simply, we're asking for the original terms and conditions to be reinstated, that being $50,000 personal with house arrest, except for being allowed to travel to and from work so that he could leave the house at 8 a.m. and return home from work at 6 p.m.
Mr. Prosecutor?
Judge, with all due respect and not challenging the sincerity of defense counsel in him stating to this court that his defendant was stressed out over this incident, I'd just like to go over a couple of particulars here. And he was given the shot with the $50,000 personal. And I understand this is a flight issue, Judge, but I just want the court to know this. Following this incident that took place where he ended up killing somebody on the roadway, and he was unlawfully on the roadway because he didn't have a license, approximately 32 days later, after he got out of the hospital, he was issued a citation for speeding 31 plus miles an hour on the roadway. Now, that's number one. Number two, subsequent to getting issued that citation following getting released from the hospital and apparently not having any stress at that point, Judge, he ends up getting pulled over for driving without a license. And this all happens in between the time of the incident and the present, Judge. And then we have in November of last year, while this defendant, I guess assumably was having some type of stress, but not a lot of stress, because he was on the roadway blowing through a red light. And then to add proverbial insult to injury this year, January, and the reason why he ended up getting picked up and got arraigned for this, he was again pulled over for going 31 plus miles an hour on the road.
Court, I haven't heard the arguments of counsel. We have a situation where a person is accused of operating a motor vehicle without a driver's license and causing the death of another person and possibly great bodily impairment to great bodily functions and the like. He was given a personal bond, given the opportunity to work. Seems like he's still driving unlawfully. And I know not driving was a condition. So what we're going to do now, we're going to continue Judge King's bond because the court finds that Mr. Nelson is a danger to the community. I'm not really concerned with flight. I find him to be a danger to the community. The bond will continue. He will have what's his work hours?
Judge, he works from 9 to 5, and
9 to
with all
5.
due respect, this.
No, I'm not finished, counsel. I'm not finished, counsel. Okay. He will have a GPS tether. He'll have a curfew. His curfew will be from 7 p.m. to 6 a.m. He is not to operate a motor vehicle. And when I mean a motor vehicle, that's anything with a motor. That is a motorized bike, that's moped, motorcycle, car, go-kart, anything that has a motor. He is not to be, anything that has a key. He's not to turn it. He's not to push to start anything. He is to take public transportation, Uber, Lyft, ride share, whatever he needs to do to get back and forth to work. But he's not to drive again. If your client drives, he will be remanded to the Wayne County Jail. With that being said, bond continues, GPS tether, curfew is 7 p.m., 6 a.m., and no driving a motor vehicle. Thank you very much, Mr. Simon.
Judge, just for clarification, was
Yes.
the bond the 50,000 personal or the 50,000 cash or surety?
No, the 50,000 cash continues. No, we're not. No personal. But he could.
There
But you
have
could
been
argue
no-
what Mr. Simon. We can't talk over each other. When you get back in front of Judge King, because he did previously have a personal bond, once he appears, you may argue that in front of Judge King. But at this time, his 50,000 KPS bond is being continued with the added conditions of not operating a motor vehicle. Okay.
Yes, thank you, Judge. That may have
You're
already
welcome.
been a condition, but thank you very much. And
See, that's another problem. If that's one of the conditions,
no
if that's one of the conditions, I'm saying that you might want to like hone that in with him a little bit, hammer it in, because driving 31 miles per hour over without a license after you're accused of killing someone with the car, that we got to kind of let Mr. Nelson have learned the seriousness of what's going on at the court right now. And I know as a great counsel, Mr. Simon, you're going to do so. So with that being said, we got to keep this moving. Thank you very much.
thank you,
All right,
Judge.
who else?
Take care.
Yes, no problem. What's your name, sir?
Here, Delone Charleston.
Charleston. Almost, LaDon. Almost.
Calling case number 240-55312-01. People of the state of Michigan versus Eric Charleston. The defendant is charged with count 1, weapons, firearms, discharged from vehicle. Counts 3 and 4. I'm sorry. Count 2, weapons, firearms, possession by felon. Counts 3 and 4, assault with a dangerous weapon, felonious assault. Count 5, weapons, felony, firearm. Counts 5 through 8, weapons, felony, firearm. Count 9, domestic violence, second offense notice. Domestic violence, second offense notice. Habitual offender, second offense notice. Today's the date and time. for a boundary determination. Appearances, please.
Judge, always a privilege. Steve Vincent for the people, P71917.
Deliberate on behalf of Mr. Charleston. Judge, can I have like a 10-second breakout room with Mr. Charleston? Like 10 seconds.
Absolutely. Let's go. All right. Argument.
Judge, my client's 48 years of age, Judge. He's not working right now. He's receiving Social Security income. This is a domestic situation, Judge. They were at the Southfield Police Station, I think, doing a child exchange. Now, obviously the story is going to be, a conflicted story between my client. He's going to say one thing, he's going to say another. Then, Judge, there's a third party. Now, again, when we talk about having a third party, there's an Uber driver. So, my client, Judge, that his car was damaged, destroyed by the complaining witness. He wanted to talk to the complaining witness. He did not see the complaining witness again until he went to his grandma's house over on the east side, Judge, and she was at her house, which they don't stay too far. Because I kind of got to him about following people. Why are you? I didn't follow anybody. I happened to be over there. She was over there. He didn't follow her. He says that's when words were exchanged. He doesn't have a gun. Never shot a gun. Doesn't own a gun, Judge. But again, these are allegations.
Okay, Mr. Reagan, just make sure I'm clear.
Go ahead, Judge. Go ahead.
Okay. So, what I have before me right now, allegedly. Yeah, this is one of my. I just want to make sure I'm clear on the allegation. You can tell me where I'm wrong or where your client is disagreeing. They're at the Southfield Police Station to do the exchange of the child. Correct.
Correct.
Who does the child? What car does the child get into? His car or the Uber?
The child gets into the Uber. That's correct, right, Mr. Charleston? The Uber or your car? Oh, the child gets in his car.
Okay. The child gets in his car.
Right.
And allegedly he follows the Uber driver.
Right.
And then there's an argument between him and the child's mother.
Correct.
This is the allegation, allegedly.
Correct.
And then he shoots into the Uber with the child in the car with him, allegedly.
That is alleged.
Am I missing something?
You're not missing anything in terms of how they wrote this document up, Judge. You're not missing anything. No.
Okay.
As
All
usual.
Right. Okay. All right. Mr.
Judge, Judge, let me just say one thing before Mr. Vincent starts. So you see what I'm saying, Judge. The child was coming with him. He wasn't trying to follow her about a child or anything. It was another situation that they just happened to end up in the same area, Judge. It wasn't a following, and I just wanted to kind of point that out, Judge.
So they started in Southfield, and they just happened to be in the same area on the east side?
Well, she lives on the east side, and his grandmother lives on the east side where he was going. They're from the east side. That's
they both the east side is the right side. I hear you. Okay. All right, Mr. Benson.
Judge, with all due respect, and I do, Mr. Reagan knows he has a lot of respect coming from me. He didn't even know what car the child was in. So, I mean, how can he come before Your Honor and talk about allegedly what happened here versus what's in the investigator's report? But I'll put everything aside for a minute. I'll put what Mr. Reagan thinks he knows about this in the investigator's report. We have a defendant who was convicted of domestic violence in 2019 against this same complaining witness. We have a defendant who has priors involving reckless use of firearms, twice over. Then we have a defendant, allegedly, Judge, who, while this young child was in the car, ends up shooting at the Uber driver. And I do enjoy Mr. Reagan's interpretation of what happened to the Uber vehicle. It was damaged or destroyed. It was damaged or destroyed because the defendant allegedly shot a gun at the Uber driver, because that bullet ended up going through the front door. There are pictures. And we do have now a witness. So this isn't really he said, she said. We have an Uber driver that witnessed the defendant doing this. So with all due respect to Mr. Reagan, and, just taking the investigator's report for what it is, we have positive ID of this defendant, not just from the complaining witness, from a witness who ended up getting shot at by the defendant. We have a defendant who's previously been convicted of domestic violence against the same complaining witness. We have a defendant who's had second notice. Judge, I think that the complaining witness she was just trying to do everything right. They were at a police headquarters just trying to exchange a child. And this defendant takes it upon himself for whatever reason to do what he did.
Mr. Reagan, last word.
Judge, just real quick, Judge, and I know the court looks at the details and things, Judge. So, we have certain charges here. One thing that the report talks about is it found one bullet hole in the driver's side door by the handle, one bullet hole. I don't know if that was a newer hole, older hole, I don't know what, but Judge, I just noticed that when you shoot at somebody in a vehicle, especially two people, FA is kind of the least of your worry. It's more like, assault with intent to murder, GBH, all of that. That wasn't charged here, Judge. They charged him with FA because a lot of this stuff is not adding up, Judge. I mean, somebody follows somebody and they know they're following somebody, then all of a sudden you take a shot at somebody and then drive away like that person doesn't know who you are. It doesn't add up, Judge. And that's why the prosecutor really didn't charge AWIM because they don't really have anything, Judge, except a bullet hole, one bullet hole in the driver's door, Judge. Now, I'm saying, Judge, it didn't happen the way in which the report says it happened. It didn't. And the prosecutor knows that. That's why they didn't charge it like that. I'm asking the court, 100,000 cash is excessive. I'm asking for reduction, Judge. I understand he has priors. I understand that, Judge. 2019, that's fine. He dealt with that. That's over with. I'm talking about this particular case. He says he doesn't own a gun. They didn't find a gun. They don't have a gun. I'm asking for reduction to a personal. I understand GPS tether is necessary, even house arrest. He's not working. He's on Social Security, so he doesn't need to be out. But I just think 100,000 is excessive, Judge.
Court haven't heard the arguments for counsel. I'm not gonna go too far into this. Court finds that $100,000 cash bond is an unaffordable bond. Court, in order to have an unaffordable bond, the court has to find by clear and convincing evidence that the defendant is a danger to the community or the complaining witness and or a flight risk. In this matter, the court does find that the defendant is a danger to the complaining witness. Court finds that the bond is excessive at $100,000, however, and I'm going to reduce the bond to $100,000, 10% with a GPS tether, house arrest, no contact with the complaining witness. Defendant may leave home for court appearances and medical appointments only. Thank you.
Thank you.
All right. You are free to go, Mr. Charleston.